Hello, everyone, and welcome to PCR's September Virtual Transition Times. My name is Melissa Wyman, and I am PCR's Respite Care and Community Engagement Director. I will be your moderator this evening, so please feel free to send any questions or comments in the chat box below. We are delighted to offer this presentation with American Sign Language simultaneous interpretation. We will also be offering this presentation with Spanish simultaneous interpretation. To access the channel in Spanish, click Interpretation in the meeting controls and select the Spanish channel. Participants in a language channel will hear the translated audio and also the original audio at a lower volume. To hear the interpreted language only, click Mute Original Audio. The English and Spanish language versions will be archived on the PCR website Transition Times page. Please share the recording and upcoming Transition Times programs with your friends and others in the community. It is very important to continue to spread the word about Transition Times so we can continue to better serve our community. I want to give a special thanks to Heidi De Paula, PCR volunteer, and Rita Scheinberg, MC Transitions, for all their help with Transition Times and the dedication to our families and their loved ones. Just some Zoom tip reminders. We are using the webinar platform. We will wait for questions at the end of the presentation, but feel free to submit any of your questions in the chat box below. Click Show Captions to see the captions for the webinar. You must select the speaking language you would like to show. We are very fortunate tonight to have as our presenter Michelle Hughes, Senior Private Client Advisor, and Debbie Zane, Senior Trust Officer, Sandy Spring Trust. Michelle Hughes has more than 23 years of experience consulting clients and advisors in the financial services industry, with specialties in estate planning and business succession planning. She is a graduate of the George Washington University with a BA in Sociology and Economics and holds a Chartered Life Underwriter designation from the American College. Hughes is a past board member of the Greater Washington Association for Insurance and a financial advisor, and currently sits on the Mid-Atlantic Board for Team Impact, a national nonprofit dedicated to pairing chronically ill children with university sports teams. Debbie Zane is the Vice President and Senior Trust Officer at Sandy Spring Bank. Debbie has over 15 years of experience in estate planning and estate and trust administration, with a special interest in special needs trust. Her experience includes working as a practicing trust and estate attorney at a small firm in McLean, Virginia, and as a trust officer for a trust company. Debbie received her bachelor's degree from Mount St. Mary's University, her doctorate degree from University of Baltimore School of Law, and her master's of law from American University Washington College of Law. She is a member of the Virginia and Maryland bars. Tonight, they will discuss the basics of estate planning, asset management, and the role of a trust company for those looking to financially protect an individual with disabilities. Michelle?
Thank you, Melissa. And good evening, everyone. You can go to the next slide, please. I'm Michelle Hughes, Client Advisor with Sandy Spring Trust, and my co-presenter, Debbie Zane, and I are happy to be with you today. As Melissa said, we're going to aim to provide a high-level overview of the basic components of an estate plan, how trusts, and in particular special needs trusts, can benefit a loved one with a disability, and the role and responsibilities of a trustee. And we'll also have time for questions at the end, so feel free to submit them via chat as we go. And with that, we can go to the next slide, and I will pass it over to Debbie.
Establishing estate plan basics. So we will first outline the basic components of an estate plan, which is essentially the preparation of tasks that serve to manage an individual's assets and affairs in the event of incapacity or death. This is the starting point of protecting a loved one from financial risks. They are all important tools for providing assistance and protection to a person with a disability. A will is a legal document with instructions on how to distribute property and how any other final wishes should be carried out when a person passes away. Power of attorney provides legal authority to act on behalf of another person. It may be specific to medical or financial affairs, or it may be more broad. A medical advance directive is specific to healthcare related decisions and can work in conjunction with the power of attorney to provide decision-making authority for a disabled person. And finally, an often overlooked part of an estate or financial plan is a trust. A trust is a legal document drafted by an attorney that spells out how assets can be used during a person's lifetime and how those assets should pass to their beneficiaries when they die. The trust is the legal entity that holds title to the assets inside. The trustee is the trust decision maker, and the beneficiaries are those that receive income or assets from the trust. The trust document explains the trustee's authority, how the trust is to benefit the beneficiary, and how and when the trust is to terminate or end. There are many different types of trusts, but we're going to discuss special needs trusts in more detail. Next slide, please. Special needs trusts. A special needs trust is a type of trust that will preserve the beneficiary's eligibility for needs-based government benefits, such as Medicaid or Supplemental Security Income, which is SSI. Because the beneficiary does not own the assets in the trust, he or she can remain eligible for benefit programs that have an asset limitation. The trust assets can then be used to supplement the beneficiary's government benefits, but it will not replace them. In addition to this very specific benefit, the special needs trust can also provide additional legal control over assets, since it spells out how they should be managed for the benefit of the beneficiary, and it provides protection from adverse legal action or creditors. And since trust assets are titled in the trust name, it also provides additional privacy. There are two main types of special needs trust: first party and third party. A first party trust is where the disabled individual uses their own assets to fund the trust. The trust may be established by the beneficiary's parent or grandparents, by the beneficiary's legal guardian, or by a court. The trust is often used to protect public benefits after the special needs individual receives an inheritance, court settlement, or other large sum of money. The trust must provide that the state Medicaid agency will receive all amounts remaining in the trust up to the amount equal to the Medicaid benefits the beneficiary received. No additions may be made to the trust after the beneficiary is 65 years old. A third-party special needs trust is created and funded by a third party, a person other than the disabled beneficiary. It can be created for a disabled beneficiary through a will, as part of a revocable or irrevocable inter vivos trust, or as a separate standalone trust agreement. This is the most common trust used in financial and estate planning for individuals with disabilities, and is often set up by parents, grandparents, or other caregivers who wish to gift money or leave an inheritance to the beneficiary without disqualifying them for government benefits. It cannot be managed by the disabled beneficiary in order to avoid disqualifying the beneficiary from public benefits. The trustee must be appointed who is not the beneficiary. It serves to preserve the beneficiary's public benefits, but provide funds that can be used for expenses not covered by these benefit programs. Unlike first-party special needs trusts, there is no Medicaid payback requirement. Next slide, please. How trust assets can be used. Disbursements from the trust must be used for the sole benefit of the beneficiary and be directly related to the beneficiary's healthcare, education, comfort, or support. Examples include care providers, care managers, non-covered medical expenses, therapies and equipment, entertainment, hobbies, trips, and other items to enhance the beneficiary's life. Some collateral benefit to a third party is acceptable, such as a sibling playing with a PlayStation or someone living in the home sitting on the sofa. Companion travel expenses are allowed if the beneficiary requires assistance. Travel for a third party to visit the beneficiary is allowed if checking on the beneficiary's well-being. If the beneficiary is receiving means-tested government benefits such as SSI or Medicaid, cash may not be disbursed to the beneficiary directly because there are limits on how much income the beneficiary may receive and how much assets can be in the name of the beneficiary. Income will lead to a dollar-for-dollar reduction in SSI payments. Income not only includes cash or checks given directly to the beneficiary, but also includes disbursements for gift cards, debit cards, or gift certificates given to the beneficiary. These are considered income in the month the disbursement is made. Disbursements for food or shelter may result in reduction of SSI benefits in the month the disbursement is made. Funds may be disbursed directly to the following people or vendors: a vendor or service provider, a retail merchant, an advocate who has purchased goods or services on behalf of the beneficiary, for example, to reimburse a family member or a guardian for something they purchased for the beneficiary. The trustee can pay the provider, the caregiver, and bills directly from the trust. And I will turn this over to Michelle.
You can go to the next slide, please. So funding the trust. The most common strategy to fund a special needs trust is to do so upon the death of either one or both parents or guardians. There are a few reasons why you would fund the trust only upon the death of the parent, grandparent, or caregiver. So once the trust is funded, it becomes irrevocable, which means it cannot be changed. The money in the trust can then only be used to meet the beneficiary's supplemental needs. This means the money will be inaccessible for any other personal or family needs. In addition, a separate tax return must be filed for the trust, and there will be special tax considerations for assets held and distributed by the trust. That being said, there are many ways to fund the trust. It can be a cash gift or transfer. It can be property like income producing real estate, investments, retirement plan benefits such as 401ks or IRAs, or life insurance proceeds. In all of these instances, it is important to take note of titling and beneficiary designations on accounts and insurance policies so that the trust is funded with the proper intent and at the right time. The way the assets are titled, or whether they have a beneficiary designation, will determine how they are transferred at the owner's death, which can be very important when planning to fund a special needs trust, since the trust is often funded as part of one's estate plan. You will want to make sure accounts and property are set up to transfer according to the intent that is spelled out in the estate planning documents. This may mean changing how accounts or assets are titled or changing beneficiary designations when you're doing your estate planning. In addition, since there are often special tax considerations depending on the type of asset, you will also want to consult a legal or tax advisor when designating which assets pass by beneficiary or by your will or by account title. A beneficiary designation will come before whatever is outlined in the will, while other accounts may pass outside of your will or trust because they have a payable on death, POD, or transfer on death, TOD designation, or because you have set up joint ownership. These are all things to pay close attention to. Next slide, please. Selecting a trustee for the Special Needs Trust is a big decision since the trustee has significant responsibilities. The trustee manages the trust assets and administers the trust provisions. Other responsibilities include reading the trust document, collecting trust property, investing trust assets, maintaining accurate and complete records, making distributions on behalf of the beneficiary, and filing the trust tax return. There will be a significant time commitment and level of expertise in financial and legal matters required. Managing property for a beneficiary who has disabilities is different than managing funds for yourself. One must ensure that the money in the trust is spent only on the disabled individual and only on services specified in the trust. This means the trustee is a fiduciary. They are legally obligated to handle trust assets in accordance with the terms of the trust document and solely in the best interest of the beneficiary. The trustee can be an individual, such as a family member or a friend, or it can be an independent single service provider, such as a lawyer, or it may be a corporation, such as a bank trust company. The trust document will also usually name a successor or backup trustee in case the first trustee is unable or unwilling to serve as trustee. Next slide, please. Did we skip one? Okay, can you go 2 forward? Okay, that's okay. I think we're missing one, so I'm just going to talk through it. So I'm going to talk about the role of a trust company. You can back up a little, Melissa. So by definition, a trust company is a separate corporate entity owned by a bank or other financial institution, a law firm, or an independent partnership. Its function is to manage trusts, trust funds, and estates for individuals, businesses, and other entities. As an example, Sandy Spring Trust was established in 1987 and was granted full fiduciary power by the Office of the Comptroller of Currency and is subject to the fiduciary standard and oversight by various regulatory agencies. A trust company can serve in several ways. It may be named in the trust document as the primary trustee or as the successor trustee if the initial trustee passes away or cannot serve for some other reason. Or they can be hired as an agent to the trustee, which means they can provide support to the trustee with custody of assets, record keeping, investment management, accounting, and distributions. In terms of the benefits of a trust company, in addition to having highly skilled professionals who are trained in trustee services, they can also act as an objective third party in carrying out the trust directions for the best interest of the beneficiary. The trust company can also provide continuity over what may be a long time period of trust management during the life of the beneficiary. Managing assets by fiduciary standards is an important part of the trustee's responsibilities. The trustee must invest and manage trust assets responsibly, taking into consideration the trust's and the beneficiary's needs for income and growth, the purpose of each asset within the portfolio, asset preservation, potential tax consequences, and general economic conditions. This should include the development of a clear investment policy statement, which is a document outlining how assets should be invested, and it should be reviewed and updated with any changes as needed. There should be no conflicts of interest, unnecessary fees, or unwarranted risks taken with the trust assets. In addition, sufficient asset allocation will mean that the portfolio has adequate diversification among different types of investments to manage market ups and downs, and that it's earning adequate interest to support the needs of the beneficiary over their lifetime. Next slide, please. Okay, so as we sum up, we can look at some best practices when going through estate and financial planning for individuals with disabilities. First, make sure you are engaging an attorney that specializes in estate planning, and ideally in estate planning for individuals with disabilities using special needs trusts. You can find additional information and resources at the American Bar Association website, which is abanet.org, abanet.org. And certainly providers such as Sandy Spring Trust have a network of specialists and can make referrals and recommendations. You should also feel comfortable with the attorney and financial professionals you engage and be able to easily understand their recommendations. Another best practice is to have discussions with applicable family members and friends before there is an event that puts the estate plan into action, such as an illness or death of a parent or caregiver. Preparation and communication ahead of time between beneficiary and trustee can go a long way in making sure your wishes are carried out the way you intend and your loved one with a disability is protected. And finally, make sure you have all of the right representatives and professionals in place and review their capacity and engagement on a regular basis. We can go to the next slide and I'll pass it back to Debbie to talk a little bit about mistakes to avoid.
Pitfalls to avoid: incorrect titling of assets. So an example would be an IRA beneficiary designation, naming the disabled beneficiary outright. Assets going outright to the beneficiary may result in disqualification from needs-based government benefits that the beneficiary has been receiving. So you want to ensure that assets going to the beneficiary who's receiving SSI or Medicaid are going into a special needs trust. Another pitfall would be lack of communication and preparation or willingness to serve. So up front, you want to make sure you communicate with the trustee that you would like to serve as for the special needs trust to ensure that that person is prepared, is willing to serve, and is aware of the other people on the team, the individuals that are protecting the beneficiary and caring for the beneficiary. With that, I will turn it back to Michelle.
Yep, Melissa, we can go to the next slide. And that's the end of our prepared remarks. Our contact information is here. So obviously anyone can reach out to us directly with additional questions, but perhaps there's some in the chat that we can talk through as well.
Yes, hold on one second when I come back. Okay, perfect. Yes, so we have more questions. So let's start with our first question. Can SNTs have multiple trustees? Do we need to clarify what an SNT is?
Special
needs trust.
Oh, okay. I just want to make sure when we use acronyms. Okay, special needs trust. Okay.
As far as multiple trustees, do they mean co-trustees?
I think they're clarifying. Steve, can you clarify if you mean co-trustees? Yes.
Yeah. Yes, a special needs trust can have co-trustees.
Okay, great. Thank you. Next question. I have already set up a special needs trust for my son, but has not been funded. If his grandmother wants to put funds in the trust now while she's still living, how do I set up, link a bank account to handle this?
Well, how do I set up a bank account? I mean, that would probably depend on the specific institution, but it can certainly be done. Like we said, you can have a cash transfer to the trust to fund the trust.
You could use either a bank account or an investment account, depending on how you want the assets to be held. If you want them held in cash, or if you would like to invest them.
All right, thanks so much. The next question is, how does the trust company get paid for services rendered? Is this a state set fee, or do trust companies have different rates for services? Does the amount of the estate affect the fee?
So it is not a state set fee, so it will depend on the institution, which may be different. I can tell you that yes, it is dependent on the services that we are providing, the type of trust, and the size of the account that we are managing, that we are trustee for. But it's an annual fee that is a percentage of the assets in trust.
All right, thank you. Next question is, do you establish the trust before you fund it? Saying funding with assets, insurance policies. So do you establish the trust before you fund it?
Yes.
Yeah. So you would want to work with an estate planning attorney who specializes in drafting special needs trust and have them prepare the trust agreement, because that is what governs all the distributions, all the investments. That's what governs everything for the trust. So you want to do that first before you fund the trust.
All right, thanks. Next question, are there any restrictions, limitations if my son is receiving SSDI versus SSI?
No, so SSDI is not needs based. So you can still have assets in your name if you're receiving SSDI. It's based on a disability, but not financial need.
What type of investments are recommended for special needs trust?
So every case is a little bit different, and so that's why it should be outlined in the investment policy statement that is guiding the trust document and the trust assets. But usually there would be a variety, diversification of investments inside the trust, so that it can weather sort of market ups and downs and changing economic conditions, like interest rate variations, that sort of thing. So it can be a variety of different investments.
All right, if received SSDI, not SSI, can the funds be used for food shelter? So there might be similar to the same question, but.
Yes. So if there is a special needs trust and the person is not currently, I guess, are they talking about is if there is a special needs trust and the person is not receiving SSI, can it be used for food and shelter? Then the answer is yes.
Okay. Thank you. Okay.
I guess the one exception would be looking at the trust document itself. If the trust document itself specifically says that it can't, then you would need to go by that. But in general, you can do that as long as they're not getting SSI.
Okay, thank you. Okay, so we have a question with a few parts to it. So first one is, how involved can and should an institutional trustee be in assessing and providing for the day-to-day expenses of a disabled individual's life? They say, for example, if the individual's need and associated expenses change frequently.
Yeah, so it's really important for the trustee to have a good relationship with somebody who is providing care. Sometimes that's a parent or guardian. Sometimes that's another relative or a close family friend, somebody that is checking on the special needs beneficiary, providing care for them, somehow involved in their life to have discussions regularly and kind of come up with a budget of what they need, and that those needs may change as time goes on. And so it's important to have those conversations and have those meetings and figure out what bills can be paid directly from the trust, what things will be reimbursed to a caregiver or a parent or guardian, and how those needs might change as time goes on.
Okay, great. Thank you. How much is it to establish a trust without it being funded?
So that will, again, establishing the trust you would do with an estate planning attorney, ideally, and that will depend, the cost will depend on the attorney that you engage. So there's a range, and it's, yeah, it's hard to say, but it depends on what the attorney's fees are.
Okay, great. How much time does it usually take for a person to be co-trustee with an institution? Our son will be a co-trustee with a financial institution. Many of our daughter's expenses are paid from her SSI account and her paycheck.
Debbie, do
So
you want
I think the question is, how much time does it usually take for a person to be co-trusted with an institution?
How much time for them to become a co-trustee? I don't really understand the question.
I think they meaning how much time would they have to invest to be a co-trustee?
the time commitment?
Yes.
Oh, okay, okay. I mean, if the family member is a co-trustee, they're probably a co-trustee because they are closest to the beneficiary and they are closest to what the needs are. But the corporate trustee is going to be the one who's doing the financial investment and management. They're going to be the ones setting up the direct, payment of bills, payment of expenses. They'll be the ones kind of calling the meetings with the co-trustee to discuss that beneficiary's needs. So it's not going to be as much time consuming for that individual family member co-trustee as it would be for a corporate trustee, but they would want to have time to have involvement in the beneficiary's life to be able to assess what the changing needs are.
Okay, and we do have a question if you are available to meet in person.
Yes. Yep. Feel free to email or call. Debbie is based in Reston. I'm based in Bethesda, Maryland, but yeah, we can do virtual or in-person meetings.
Okay, great. I just want to ask if anyone has any additional questions. Is there anything you would like to add, Michelle or Debbie, before we wrap up?
I don't think so. We really appreciate the opportunity to be here, and again, are happy to answer additional questions via phone or email. You had our contact information up, or I guess everyone will have the slides available so they can know where to find us. And we're glad to be with you.
Oh, perfect. Okay, so we got one more question. Are there any pitfalls or issues if a special needs person is a beneficiary of a foreign established trust?
I'm sorry.
You mean a special needs trust established in another country?
Yes. If
That's
Steve,
you can
if you can explain that question a little bit further. All right, when we're waiting for Steve to explain that a little bit more, can you take a bit more about pitfalls to avoid for special needs trusts based on your experience? Can you explain a little bit more?
Pitfalls for special needs trusts?
Yes.
Drafting them or pitfalls for drafting or pitfalls for administering them?
Can we talk about both?
Sure. So for drafting, I think pitfalls would be not working with somebody who really is an expert in this. It's really important that they are drafted properly so that the way it's drafted will not disqualify the beneficiary for benefits that they're receiving. Also, if it is a first party trust, many states, especially Maryland, require, or it would be a good idea to get them to review the trust document before it's executed. because those are Medicaid payback trusts. So it has to have very specific provisions in there. Okay, I see something in the comments. Pitfalls in executing the trust. So in executing the trust, it's really important to have a trustee that understands disbursements from a special needs trust, because the disbursements are important because you don't want to disqualify that beneficiary from receiving the government benefits that they're receiving. So that the trustee needs to understand what can and cannot be paid and who it can be paid to directly. They need to understand that, they don't want to give income to the beneficiary. They don't want the beneficiary to own assets outright that might become disqualified.
So I'll just comment, again, that's what we were saying. Sometimes we'll see people that have trust documents drafted, set up, but they're not funded properly in terms of, making changes to their beneficiary designations or retitling assets so that the trust actually gets funded the way they want. So it's sort of a two-step process. And so occasionally we see people that, didn't carry through with that, or something changed, divorce or death, and they didn't update those things so that it didn't get funded properly. I'd say that's another, mistake we see.
Okay, thank you. So we did get clarification on Steve's question. So we have a family trust established in another country. Our special needs daughter is a beneficiary. Any problems if she receives distribution from such a trust?
That is a good question that I don't know the answer to. It may depend on the state where she's receiving the benefits. So if it's Maryland or Virginia, it may depend on their, it just depends.
Okay, all right. So, and then this is kind of another question. If the guardians or primary caregivers are outside the US, such as Canada, will there be an issue to dispersing trust funds to them?
I don't think so. You mean to reimburse them for an expense that they paid on behalf of the beneficiary? I don't think that would be an issue. She said yes. I don't think that would be an issue.
All right. Well, thank you. Okay, great. Thanks. All right. So thanks again. All right. So thank you, Michelle and Debbie Zane, for your wonderful presentation. Please join us on Wednesday, October 25th from 7 to 8 to learn about Safe in Home and how remote supports can be used to modernize personal supports. This webinar will be presented by Andrea Vincent, District Manager, Virginia, Maryland, North Carolina, Oklahoma, Washington, Colorado, Safe in Home. Thank you and hope to see everyone in October.